Okay, everyone, it's Tuesday, so you know what that means. It's a Teaching Tuesday. Let's do a Teaching Tuesday. I've done previous videos in regards to the class action lawsuits against NAR, the National Association of Realtors, and the various NAR-owned MLSs, and so forth and so on. So, a lot of working parts. We're going to see how this thing plays out, but already nationwide, there's changes that are being done to contract documents, brokerage documents. Locally here, REIN, the Real Estate Information Network, has changed their docs to come in line with the latest decisions nationwide in regards to all these class action suits. I wanted to kind of point out a possible pitfall that I see already in regards to the changes. So essentially, they're trying to separate, okay, the seller is going to agree to pay their listing agent a certain fee, certain compensation for those services rendered, and the buyer is going to separately agree in a separate brokerage agreement with their agent, known as the selling agent, what that compensation is going to be. Now, the seller may agree to contribute to the buyer's agent, but they don't have to. However, let's take a look at the new provisions in the new version of the REIN contract, which was last revised on February 12th of 2024. So particularly paragraph 17 now sets forth that at closing, the seller shall pay a brokerage fee due the selling firm in the following manner. So it can be either, for example, a percentage of the purchase price, or it can be a flat fee, and which brokerage fee is deemed earned as of the ratification of this agreement. All right. So the listing agent and the selling agent, representing seller and buyer, they are by definition third-party beneficiaries of this REIN contract, meaning that they can enforce it as a party. So how could that be a pitfall? Well, the listing agreement with the seller, all right, and the listing agreement, that's not shared with the buyer, all right? The buyer may not have any idea, for example, if the seller is paying the listing firm 4%, 5%, 6%, 10%, all right, or a flat fee of 10 grand. Same thing for the buyer side, all right? So the seller may not know the compensation agreement between the buyer and the buyer's agent. It could be an enormous amount, all right? So how does that play out here? So paragraph 18 defines the default and goes into remedies of a default. So let's say your buyer just has cold feet and they fail or refuse to close. So they're in breach of the contract. The defaulting party shall be liable for brokerage fees due to listing firm and the selling firm, as if the transaction contemplated hereunder had closed, which may include brokerage fees not disclosed as a part of this agreement and payable to the listing firm and or the selling firm, pursuant to separate agreements between the buyer and or the seller. So as an attorney, I'm thinking, wow, how's this going to play out? So let's run it out. Let's say that the listing agreement, the seller has agreed to pay 7% of the purchase price to the listing agent, okay? And then the buyer has an agreement where the buyer agrees to pay 3% to their agent. So we got a total of 10% now, all right? And for whatever reason, the buyer breaches a contract and fails or refuses to close. Well, the agents as third-party beneficiaries now can sue for their commission that they were due and owed pursuant to their separate agreements that are not disclosed to the buyer. So for example, the listing agent could say, hey, I have an agreement with my seller that I was going to get 7% of the purchase price. So now I'm going to sue you, buyer, and you have to pay me 7% of the purchase price. At the same time, the buyer's agent, the selling agent, could also sue for the commission, which was an additional 3%. All right, so we got now a combined 10% of the purchase price. So the pitfall here, or the risk here, is really on the seller and the buyer in that they could be exposed to litigation, exposed to liability for an undisclosed amount, pursuant to a separate agreement that they were not a party to, nor was revealed to them. So I don't know, guys. We're going to see how this thing plays out, but I think it could be a possible pitfall, and it could lead to additional litigation in regards to paragraph 17 and 18. I will keep you advised. See you soon.